Shalom to yet another webinar that we are offering in partnership between Hiddush, Hiddush, Rabbis and Candidates for Religious Freedom and Equality in Israel, JPLAN, the Jewish Pluralism Legal Action Network, and AAJLJ, the American Association of Jewish Lawyers and Jurists. We are grateful to the leadership of all of these organizations who are with us and working with us closely to enable us to share this unique opportunity to learn online. And today you are in not only for an intellectual treat, but also for a practical enrichment, because with us is Nicole Maor Center, I would estimate the #1 expert on who is a Jew, registration of Jewish status, law of return and population registry and entry rights into Israel. And that's a maze, a very, very complex maze. Nikki made Aliyah many years ago from Australia, having been a leader in the a young leader in the Australian reform movement. And I had the privilege of working closely with her for years during my tenure as head of the Israel Religious Action Center, subsequently being succeeded by the very capable Anat Hoffman. Nikki has been heading the advocacy centers for Olim, LACO, that has helped thousands of Olim in various areas, and one of them is, as one can expect, the area of who is a Jew registration, and has been a source of tremendous service to numerous converts to Judaism who have made Aliyah. This is the second part of a Who is a Jew 2-part series, and I think that many of you have been with us a couple of weeks ago when Professor David Allenson and Dr. Mark Angel, Rabbi Allenson, Rabbi Angel were able to share with us insights as to the rabbinic and halachic aspects of the Who is a Jew question. And this time we are going to be tackling the legal questions, and we promised the colleagues, many of you are online. We now have 65 participants in this webinar, and the number is going to grow. We had a record number of people who registered, I think around 150. And I'm sure many of them and many more will be watching the recording of this webinar afterwards. So Nikki will open up with a presentation of the issue with a focus on the questions that our overseas, our diaspora communities, rabbis, individual converts, Jewish leaders are confronting, because this is a complex issue that everybody knows of its importance, but very few actually understand the ins and outs of it. And there is no one that understands it better than Nikki. So we will start with her presentation. I will potentially, we'll see how it goes, because she may be leaving very little for me, but I may add just a little bit after she finishes. We'll engage in a little bit of a conversation, and I urge you this time more even than in previous webinars, because we want to be of service and help to you. I urge you to post your questions through the chat, and we'll try to address them in the time available to us. And if it turns out that we just don't have enough time, we may look at it again. One more word before we start, and that is on July 20th, at the same time, We will have Professor Rivka Weil of the Interdisciplinary College provide us with yet another legally oriented webinar, but really of importance to much more than just the lawyers. Her topic is the true meaning of the Barak legacy, namely not Ehud Barak, Aharon Barak, the past Chief Justice of the Israeli Supreme Court, about whom the American Supreme Court Judge Elana Kagan said he is my legal hero, and for a good reason. Much of the debate over the rule of law in Israel today and the role of the Supreme Court today is due to the genius of Aharon Barak and to the boldness of Aharon Barak and their creativity. So her topic, and she clerked for Chief Justice Barak, and her topic is the true meaning of the Barak legacy. When should the Israeli Supreme Court use its power to invalidate Knesset actions? So a very hot topic, very relevant to the current political battles and the legal political battles in Israel. Stay tuned, July 20th. I hope many of you and many more will join us. Well, with that in mind, and with people with us from the US and Canada and Europe and Israel and possibly even beyond, we are ready for you, Nikki. Take it forth.
Thank you very much, Uri. Thank you for inviting me. I think the only people who aren't going to be here are my co-hosts from Australia, because I think it's about 4 in the morning. So I apologize in advance if my accent is problematic. So if you have questions about my accent, feel free to ask as well. So we're going to start just by going over right from the beginning, the basic of what is and who is the law of return, because there are almost no other countries in the world that have a policy of return that is basically written on one screen. And this in 1950, when Israel wrote the law of return, which was 2 years after it became an independent state. Basically, he didn't think that anyone in their right mind would want to come to Israel if they weren't Jewish. So they wrote this literally one-page law that says every Jew has the right to come to this country as a new immigrant. And actually, it's interesting, when I was preparing this now, and it's the original version said that a new immigrant visa shall be granted unless the Ministry of Immigration is satisfied the applicant is engaged in an activity against the Jewish people, etc. That was then changed to the Ministry of Interior in 1954, and I actually think that if we had left it as the Ministry of Immigration rather than a Ministry of Interior, the whole picture of the law of return may have been different today, because the Ministry of Immigration is traditionally a ministry that has been run by non-Orthodox members of Parliament, whereas the Ministry of Interior has been run, for the most part, by Orthodox members of Parliament, and that has affected the way that the state has treated the law of return. But anyway, so as you can see, when the law of return was passed in 1950, it was a very, very simple law. There was no definition of who was a Jew. It was just every Jew has the right to come to this country. And during those first 10, 20 years, there really weren't questions asked. Somebody came and said, I'm Jewish and this is my wife. It was assumed that the person and their family is Jewish, and not too many questions were asked. This started getting questions started getting raised in the 60s. The first major problem that arose from the simplicity of the law of return was the Brother Daniel case, where we had someone who was born to a Jewish family. There was no doubt at all that he was born Jewish. During the Holocaust, he was saved by a Christian family, and the family brought him up as Christian, and ultimately he became a priest. And he decided that he wanted to make Aliyah, and the question was, well, is a priest a Jew? He was born to Jewish parents. According to religious Jewish law, Jewish halakha, you can't convert out of Judaism. So on the one hand, according to halakha, Jewish law, he was a Jew. On the other hand, everybody knows that he was a priest. He was a practicing Christian. And this case came to the Supreme Court because that was the court at the time, up until very recently, which tried to deal with the definitions and how one should interpret the law of return. And the Supreme Court held that, and this is the first ruling that was very, very important, it's basically held up until today, that the law of return is not a religious law, it's a civil law. And as a civil law, we're not going to apply halakha, Jewish law. We're going to apply the civil and Zionistic interpretation. And that interpretation will be, how does the person in the street see this person? Would a person walking down the street seeing Brother Daniel think that this person is a Jew or think that person is a Christian? If the answer is that they're not to be seen as a Jew, then obviously he's not a Jew for the purpose of the law of return. And that was the first big issue of limitation or changing of the definition of the law of who is a Jew for the law of return. And following that case came this case of the Shalit family in 1968-69. Shalit was a captain in the Israeli army. He obviously was Jewish. He married a non-Jewish woman and they had children. Now, again, according to halakha, Jewish law, their children were born to a non-Jewish mother. He wanted his children to be registered as Jewish in the population registry because at that time, your religion was registered on your ID card, and it was quite significant as to whether you were registered as Jewish or not Jewish. And he wanted his children to be registered as Jewish. He said, according to the Brother Daniel definition, my children look Jewish, smell Jewish, sound Jewish, act Jewish, and so they should be recognized as Jewish. And it's really irrelevant for the purpose of the law of return or the purpose of registration, which took the same definition, that they are not Jewish according to halakha. And the Supreme Court, on a ruling that split 6-5, was one of the biggest benches of the Supreme Court, held that he was correct, that according to the rationale of Brother Daniel, the Shalit children should be recognized by the State of Israel as Jewish. This, of course, led to a huge balagan, as they say, a huge outrage by the Knesset, and they immediately said, we have to now change the law of return. We are not going to be prepared for Israel to accept someone who is not halakhically Jewish as a Jew. And so we come to the massive amendment in the 1970s. This is really the last amendment that was made for the law of return, even though they've been trying to amend it numerous times since, but it's never actually happened. And what they did was that on the one hand, you can see there's 4A and 4B, whereas previously there was just 4 that said a Jew can make aliyah. They've now said on the one hand that the rights of a Jew are also vested in a child and grandchild, spouse of a Jew, spouse of a child, spouse of a grandchild, etc. But there is now a definition of a Jew, and the Jew is a person who was born to a Jewish mother or is converted to Judaism and is not a member of another religion. So here we have the answer on the one hand. The Brother Daniel case is not considered a Jew under the law of return because he was born to a Jewish mother, but he is another religion. The Shalit case are no longer Jewish because the children have to be born to a Jewish mother or converted, and they were only born to a Jewish father. On the other hand, the rights of citizenship, of getting aliyah, of coming to live in Israel have been broadened to include their arguments as to how they managed to get to second generation, whether it was Nuremberg, whether it wasn't. But the result is that the law of return now applies not only to a Jew, but to all their immediate family. And we won't have time to get into all the complications that have arisen by this broadening of the definition. Suffice it to say that, again, this law is a declarative law, and the page is a little bit longer, but it's only one page, and a one-page law really cannot deal in today's complexities of all the issues arising from immigration and coming from one country to another. And unfortunately, the law of return really is not answering all the questions that need to be answered by people who want to make aliyah, and we'll touch on those as we get a little bit further down the track. So let's move straight on to the big question that really affects us as non-Orthodox Jews, or generally all around the world, and that is the question of who is a convert. As you saw previously, there was no definition of a convert in the law of return, and it's not by fluke. There was a huge issue raised in the Knesset at the time. How do we define who is a convert? Should a convert be someone who's converted according to an Orthodox halakha? And ultimately, in the end, it was decided that they're not going to define who is a convert because of the respect that the Israeli Knesset should have to the Jewish congregations overseas. It's not Israel's right to determine how the diaspora, how the Jewish world outside of Israel runs its congregations. And so we'll leave it open. You know, one of those hot potato issues which I think they've regretted ever since, because since then they've tried to pass a who is a convert law so many times, but they actually haven't succeeded up until today. Partially or largely because of the involvement of the diaspora Jews who say very, very clearly they're not prepared for that to happen. But in any case, so who is a convert? For the first time it came to the Supreme Court, and I'll try and go through this relatively quickly, in 1986. That was the first time that the whole question of convert hit the Supreme Court, and that was Susan Miller, who converted to Reform, and then she wanted to be registered as Jewish in Israel, and the Minister of the Interior, who at that time was for a change, or not for a change, as usual, Orthodox, said, I'm not registering her as Jewish, came to the Supreme Court, and they backed down, and she was registered as Jewish on the basis of her non-Orthodox conversion. Come 1989, and the Shas party was ruling the Interior Ministry, and they petitioned the Supreme Court against the registration of a non-Orthodox convert as Jewish. And this is the first time that the Supreme Court came out very clearly and said that a person who is converted in a recognized Jewish community, and we'll talk about that in a minute, overseas, will be registered as a Jew for the purpose of registration in Israel's population registry. And seeing it's the same, the definition of who is a Jew for the registration in Aliyah is the same definition. At that point, the Supreme Court said, well, if it applies for one, it applies for the other. So in 1989 was really the first time the Supreme Court came out very clearly and said a person who is converted in a non-Orthodox congregation that belongs to a recognized stream of Judaism. What's a recognized stream of Judaism? Reform, conservative, or Orthodox. Now, if you see the time scale, in 1989, 1991, 92, this was the time of the big aliyah from the former Soviet Union. It was also the time of a large influx of foreign workers into Israel, or basically all around the globe was the beginning of the great global movement and the changing of the borders. And there were a large number of people who were living in Israel illegally, and the Interior Ministry decided that it was going to go on a rampage and start kicking people out of the country if they weren't Jewish. And this gave rise to fictitious marriages on the one hand, but it also gave rise to people who were wanting to convert in Israel in order for them to get citizenship. And up until that time, there was no recognition of conversion performed in Israel. So what these people did was, and I mean, the Reform movement in Israel played the game as well. They studied in Israel and then went overseas and converted overseas, because in 1989, the Supreme Court has said that conversions performed overseas will be recognized for the purpose of the law of return. And these ended up being called quite derogatively quickie conversions. They're people who studied in Israel and then went overseas and converted overseas. And between 1989 to 2005, this issue went back and forth through the Supreme Court. Are these conversions performed in Israel? Are these conversions performed outside of Israel? The Interior Ministry claimed that for a conversion to be recognized outside of Israel, the person has to live in a congregation outside of Israel, has to be an active part of a congregation out of Israel. And therefore, these people who are living in Israel and jumping overseas in order to convert can't be recognized as Jews for the purpose of the law of return. And in 2005, finally, after an awfully, as you can see, these cases, by the way, were served in 1997, 1998. So we're talking about eight or 9 years. The Supreme Court came down and for the first time said very, very clearly, anyone who converts in a recognized Jewish community overseas, be that community Reform, Conservative, Orthodox, will be recognized as a Jew for the purpose of Aliyah. It doesn't matter if the person converting was a member of that community, the converting community, before they converted. They could be members of a community in Israel. Therefore, it is absolutely irrelevant whether the person is living in Israel or living overseas before the conversion, on one condition. And that condition is that the person can prove that the reason or the motivation for the conversion was not solely to get status in Israel, i.e. they weren't converting fictitiously, but they were converting for the sake of wanting to join the Jewish people as a whole, and Aliyah was just a furthering of that desire to live a Jewish life. so that the question was, well, how to determine whether a person's conversion is a fictitious one or a real one? And the judges were split over this question. Barak and Aaron Barak said that he felt that so long as the conversion was performed in a recognized Jewish community, we trust that Jewish community, and if they say that the conversion was according to its rules, then that's fine by us. Other judges said, no, we think that the Interior Ministry has the right to serve criteria and to make criteria to determine under what conditions a conversion performed in a recognized Jewish community will be recognized for the purpose of Aliyah. And as you can see again, this judgment was held in 2005, and it took another 10 years almost to serve criteria. So the question, and so this is again, well, this is saying what the criteria had to come and work out. What are the abuse of Israel's immigration laws? And I'll very, very quickly go over these criteria, because these are really the criteria that are valid up until today in terms of recognizing conversions performed in congregations overseas. So you have to study for at least 9 months. So if somebody studies for less than 9 months, they have a problem. They have to be involved in a congregation. It doesn't matter whether it's the converting congregation or another congregation, but they have to be involved in the congregation for at least nine months after the conversion. They need to be face-to-face classes. They don't want people studying over the internet. They have to have some sort of connection with the Beit Din. If they have all of those things, then in theory, the conversion should be recognized for the purpose of Aliyah, unless there are circumstances raising doubts about the validity of the conversion. What are these circumstances? If you've stayed in Israel illegally in the past, you've previously required status in Israel, you've requested a status for Israel and you've been denied, and then all of a sudden you turn up and you've converted, they'll say, hey, wait, there's a problem with the conversion. The Interior Ministry have written down this third circumstance, which I find absolutely outrageous, and we fight it in the court all the time, and that is that family living in Israel who haven't converted to Judaism. So we have lots of cases of, for example, fourth generation Jews, people whose parents and grandparents made Aliyah because they were children of a Jews or grandchildren of Jews. They couldn't make Aliyah because they were already the next generation down, and they converted to Judaism. But their family living in Israel didn't convert. They live as Jews, or they live however they live as secular people, and they didn't convert to Judaism. As far as the Interior Ministry concerns, if you have family living in Israel who haven't converted, that is prima facie raises questions as the validity of your conversion, because they fear that you're coming to live in Israel with your family and not coming to live in Israel because you want to be Jewish. Again, we're fighting this in the court in numerous cases, but unfortunately this has not yet been struck out of the criteria that have passed the Supreme Court. Again, conversion in close proximity to the Aliyah date when only one member of the family converts. Again, this raises a fear. This again is a circumstance that really isn't really in sync with the realities of many families overseas, where it's accepted that one member of the family converts and the other member doesn't convert because they don't feel religious enough that they want to convert. It doesn't mean that they're not supporting the conversion. And in those cases, again, the Interior Ministry raises questions and will cause problems with the Aliyah. And obviously, again, if a person was living in illegally and trying to convert in Israel before then converting overseas, that will raise issues according to the Aliyah. And what happens is that ultimately, if you're living in the States or Canada or Australia or Europe, when you apply for Aliyah, your Aliyah request goes to the Jewish agency, and the Jewish agency has the power to check your Aliyah request. And if you don't have any of these circumstances, then the Jewish agency has the power to approve your Aliyah. If you have any of these circumstances, the Jewish agency sends your file to the Interior Ministry, and then you're in trouble, because then the Interior Ministry gets involved and you could be waiting for years and years until they give an answer, or having to go to the court to get a positive result. So that was the general situation up until 2015. In 2015, we brought a case of women who converted in a small town in Peru, a place called Pucallpa, which was a developing community. What is a developing community? It was a community actually of fourth generation Jews whose family had either made Aliyah or were living in Iquitos, which is another Peruvian town in the Amazonas, which had a Jewish community. It's a long story, but it had quite a thriving Jewish community. Anyway, these fourth generations studied in Pucallpa They were all not Jewish, obviously, they were fourth generation. They studied together, then they went to the community in Iquitos and converted there, and then asked to make Aliyah. And the Interior Ministry said, hey, wait, you don't fit the criteria, because when you were studying for your conversion, although you studied for 9 months, your community wasn't a recognized Jewish community because you're all converts. So we're not going to recognize your request for Aliyah because your congregation or your community that you were involved in wasn't a Jewish congregation. And so they've, since that time, this whole issue of developing communities has raised more and more questions as to what is a recognized Jewish community. As far as the both Reform and Conservative movements are concerned, the moment whether a person is a Jew by choice or a Jew by birth is completely irrelevant. And once the community is recognized and becomes a member of the Reform movement or the Conservative movement, or even an Orthodox, there are Orthodox communities who are developing communities, then there's no longer any role the Interior Ministry should have in questioning whether that community is Jewish enough for a convert to make Aliyah. Unfortunately, this isn't happening, and we're finding more and more congregations being questioned as to are they Jewish enough? Is the community should their Jewishness be recognized by the state? And this is not just a question of congregations based on Jews by choice rather than Jews from birth. And you have I don't know how many of you are aware, there's the whole story of the Abu Yudaya Jews, the Jews in Uganda, who again, hundreds of years lived lives as Jews, but they weren't Jews by halakha. They were then all converted, and some of them want to make Aliyah. And the Interior Ministry says, no, you can't make Aliyah because your congregation before you were converted wasn't a Jewish congregation. And the Interior Ministry, the moment they're getting their claws into the whole concept of Jewish community, are also asking more and more questions as to how the congregation runs itself, i.e., again, is a congregation that has no permanent rabbi, recognized Jewish community, even if it's a member of one of the world union, one of the world movements? What happens to a congregation that holds services once every 2 weeks or only on a Friday night? Is that congregation good enough or justifiable enough for somebody who wants to make conversion within its framework to make Aliyah? So recently we had a convert from the congregation in Rome. Rome was holding congregations once a month. And this person converted in that congregation. The congregation is a member of the World Union. The Beit Din was the European Beit Din. So everything is kosher as far as that concerned. And the Interior Ministry said, no, the fact that the congregation only holds services once a month is not serious enough, and we're not going to recognize it as a Jewish community. For the purpose of Aliyah and getting new immigrant status, we took that to the court and we did win it. But it hasn't stopped both the Interior Ministry and now, unfortunately, the Jewish Agency from getting more and more involved and asking more and more questions as to the congregations and to their makeup, as to how many rabbis I have, who formed the congregation, when was it formed, does it have bar mitzvah classes, does it have Sunday schools, and really getting more and more involved into the life of the Jewish community overseas. The same issue is arising, and especially now is relevant because of Corona and then COVID, is online conversion classes and online services. This is going to be an issue that Israel is going to have to face, because up until now, if people had online conversion classes, it was, as I said before, looked down on very severely. Again, it was felt that a conversion has to be performed within a framework of a congregation. And the moment that it's done online, there's no congregational aspect. Obviously, in today's day and age, that issue is going to have to be addressed. But at the moment, it still hasn't been addressed. So the question of conversion is now really one that we're unfortunately having to go to court about once a month for people who are trying to convert and get status in Israel. It definitely is an issue that is going to need a lot of support from you guys from overseas, because the Interior Ministry is really trying to limit as much as possible people making Aliyah from what was in the past seen as quite an easy and well accepted concept of a recognized Jewish community. I haven't yet touched on the question of conversion in Israel, which is another hot potato of itself. because I think we're going to run out of time. But I just want to touch on a few other issues that are affecting the whole question of Aliyah and the law of return for congregations and for Jews living outside of Israel, which really affect you guys. And just so you understand, again, the issues that are arising from the way that Israel, and I guess in many ways, many countries in the world are becoming more and more afraid of the stranger. They're becoming more and more limiting and trying to limit without changing the law in the Knesset. They're trying to change the law in practice by limiting the people who can make Aliyah. So for up until now, I'll just give a couple of examples. Up until now, it was very, very clear that anyone who is married to a Jew, married to the child of a Jew or a grandchild of a Jew could make Aliyah. That include wives and or widows. Now the Interior Ministry is trying to say, no, if the Jew, the patrilineal Jew has passed away, then their widow can't make Aliyah anymore. We think this is ridiculous, but we are actually now in the Supreme Court for months fighting over this case. And it's going to be relevant for more and more congregations, both in the States and in the former Soviet Union, when patrilineal Judaism is a really accepted concept. In the former Soviet Union, for example, a patrilineal Jew generally had a much stronger Jewish identity than a matrilineal Jew because of the way the society was run. And so a widow of a patrilineal Jew was generally more involved in the Jewish community than a widow of a matrilineal Jew. But that is really not affecting the way the Interior Ministry is looking at things. I saw that Amir was online just before. He was involved also in a case where the Interior Ministry sees left-wing Jews as a threat to the nation's security. We've had cases of young left-wing, God forbid, Jews who've decided that they want to come and live in Israel, and before they decide to make Aliyah, they've been involved in, for example, programs that teach tolerance between Jews and Palestinians. They've been on programs that take them to the West Bank, and all of a sudden, the Interior Ministry is saying, we've seen that these people have been Bethlehem, they've been in places that we don't consider as places that is in the best interests of the country, so we're not sure whether we're going to let them make Aliyah. Of course, this is absolutely outrageous, but you need to know that this is happening. The question of the population of disassociated Jews, i.e. what happens if you're not involved in a synagogue? How do you prove that you're Jewish in the States? In the former Soviet Union, for example, your ID cards and your birth certificates have your religion or your nationality registered on there. But in the States, in Australia, in France, there is no formal documentation of Judaism. And up until now, the only way you could prove Judaism for the purpose of the law of return was if you got a letter from a rabbi saying that the rabbi knows you and your parents and knows that you're members of the congregation and are Jewish. There are more and more Jews who can't do that. And the question is going to be raised, how are we going to help these disassociated Jews prove that they're Jewish? And again, this question is going to be one that's going to have to be discussed, because it's getting more and more and more difficult for the generations as they go down to prove that they're Jewish for the purpose of the law of return. And what happens, unfortunately, is, for example, you have these great programs like Birthright, who are trying to reassociate Jews with Israel and letting them come to Israel. All you need to do to go in a Birthright program is to declare that you're Jewish. And so a lot of these young people come into Israel with absolutely no problem. There is an agreement that a person who comes to the country on birthright and falls in love with the country can then stay in Israel for another 6 months on a working visa. During that time, they can find ways to get documentation to prove that they're Jewish. And we're finding that a lot of these people after 6 months really want to make Aliyah, and then they're in a problem because they have no way of proving their Judaism. And this is going to be an issue. This, of course, causes a lot of heartbreak and distress, and we're going to have to try and find some way of solving it, which I'm not quite sure what the solution is right now, but we're going to have to think about it. The same issue really arises, and I suppose it's a direct continuation of that issue, and that is what happens if my parent converted out of Judaism because they got married to somebody who wasn't Jewish. what's going to happen to my right in terms of my eligibility to make aliyah. Under the law of return, it says you're enough to be a grandchild of a Jew. So, for example, if my grandmother was Jewish but my father married out, I should still be allowed to make aliyah as the grandchild of a Jew. However, the Supreme Court, unfortunately, has held that if your parent converted out of Judaism and you have kept the same religion of your parent, then you are no longer eligible under the law of return. So if you were born to a Jewish mother who converted out of Judaism and you were brought up as a Christian because your mother converted out of Judaism, then your right to make aliyah has gone. And this is, again, a new change that has limited the eligibility under the law of return. Mental illness. We're seeing cases now where people who have some sort of disability or mental disability, and the Interior Ministry is saying, we're not sure that a person with a mental illness is maybe a threat to society. Again, under the law of return, there is no limitation to a person who has a mental illness or physical or mental disability. The Interior Ministry are raising issues and making difficulties for these people. And the same thing applies with a criminal past. What happens if you were you were charged once with smoking marijuana 10 years ago? Is that a criminal past that justifies refusal? Everybody would agree that's ridiculous. Obviously, it can't be. But the question is, what can be a criminal past? And again, under the law of return, it's supposed to be determined in a limited way. The problem is in Israel is that limited way is given to the authority of the minister only. And so a person comes into Israel and has to show what their criminal past is. If they have any sort of criminal past, whether it is from smoking marijuana to something much more serious, their case then goes to the Minister of Interior, and it can stay there for 1 or 2 or 3 years while that person is stuck in a limbo. Again, because there are no regulations and there are no rules and there's no forms and terms in effect that can actually help determine what criminal past justifies refusal. And of course, not everybody can go to the court and try and get their cases heard. So I'm going to quickly, I just want to show you, this is in Israel, there are so many issues about conversions performed here that I really don't have time to go through it. All that you can see is that there's been conversion bill number 1, conversion bill number 2, conversion bill number 3, and right now in 2020, we're talking about conversion bill number 4 that are all trying to prevent the recognition of non-Orthodox conversion performed in Israel. The case that is pending before the Supreme Court is one of the longest cases pending before the Supreme Court. Uri and I served it in 2005, and we're now 15 years down the track. And Uri's got a lot more grey hair. I don't have quite as much grey hair as Uri does, but we still haven't got an answer. And the Knesset is trying to pass a law in order to prevent the Supreme Court giving a hearing, giving a judgment, because everybody knows that the Supreme Court will give a judgment saying that there is no difference between conversions performed outside of Israel and in Israel. And the Supreme Court is afraid to give its judgment because it's afraid, as it was 30 or 40, 50 years ago, that it's going to cause a huge raucous in the Knesset. And the Knesset knows that if they pass a bill, it's going to cause a huge raucous with all of overseas Jewry. So that is why for the last 15 years, there's been nothing happening on that field. So in conclusion, I think I've got to conclude. I've been told I've only given half an hour. The law of return is dynamic, and it's constantly being addressed and challenged by the Interior Ministry, especially as the number of non-halachic Jews, as far as the Orthodox are concerned, rise, and whether it's from the former Soviet Union, or whether it's from Ethiopia, or whether it's from the Western European countries or the States, the battle lines are being drawn because they know that their influence is getting lower. It's getting lower and lower. So those challenges are there. Who is a convert for the purpose of the law of return? It continues to be a political hot potato, especially conversion performed in Israel. And so what we find is that we need your help as much as possible. We need you to be actively involved. We need you to fight for anyone who has struggles to get recognition under the law of return. Use us, and we will take as many battles as we can to the court. And up until now, we've won most of them. and hopefully that trend will continue. Uri.
Thank you, Nikki. And I think those on this call, at this point, 74 of us, will agree there is no one like you.
That's not bad, I'm not sure.
Leading expert on anything and everything that has to do with who is a Jew and how it's interpreted in the Israeli courts. So before I try to add just a few impressionistic touches, there is one question that is of interest to many on this call, and we are constantly being asked. You mentioned, on the one hand, Reform or conservative Orthodox, and on the other hand, you mentioned developing communities. So one question was, what is recognized Jewish community beyond those two poles? Namely, what about Reconstructionist? What about Jewish renewal? What about humanistic Judaism? What about unaffiliated synagogues? Obviously, there is no simple answer, but what would you suggest the answer to be?
Well, thanks, Uri. I try to avoid the difficult questions. The Reconstructionist one is easy because the Reconstructionist Jews are seen to be part of the Reform movement. So they're an easy one. I'll put those aside.
Of the World Union for Progressive Judaism.
Sorry?
Of the World Union for Progressive Judaism.
That's right, that's right.
Not Reform, but they're part of the umbrella.
Yes, yes, they are. And as far as the Interior Ministry is concerned, they're a recognized Jewish community. When we drew up the criteria in 2014, we deliberately wrote that a recognized Jewish community is one that is a member of one of the recognized streams of Judaism or is recognized by the Jewish Agency. We left we try to include as many non-affiliated congregations by allowing the Jewish Agency to consult with the federations, with the communities in which that congregation takes part. And if the community in which that congregation exists says, yes, we know this congregation, there are thousands of people who are members of this congregation, whether it's a renewal or whether it's an independent congregation because it's not paying dues, we see it as something that's a congregation that's actively involved in the Jewish community, and we'll stand behind it. What we find is the Jewish Agency, unfortunately, is very wary of using that jurisdiction and that authority that it has. The problem, for example, with renewal congregations is that they don't have a drawn up guidelines for conversion, and the Jewish Agency is very worried that somebody can just turn up and be converted the next day if there are no clear guidelines. So they're very cautious. But it's going to be an issue that's had to be dealt with because there are more and more congregations that are being created that aren't members of recognized Jewish communities. And yet, basically, it should, as far as I see it, it's going to have to be a battle with the Jewish Agency. And these congregations are going to have to go and say, you should recognize us as recognized congregations.
Thank you. I want to emphasize what Nikki just said, namely a recognized congregation has not been defined by the court, but I think that a fair account of what will be considered a recognized congregation is a congregation or a community in good standing. And towards that end, indeed, Nikki's mention of the federation, the Jewish Federation, as sort of a local umbrella that is not part of the internal denominational battles, is a good avenue for, I think, for leverage to ensure that the Israeli courts recognize conversions taking place under their auspices. Namely, to the extent that a community, whether it's renewal, whether it's independent, I think that with humanistic Judaism there may be sort of an additional element that I'm not sure how the court will deal with it. But to the extent that it's not part of the umbrella of Reform, conservative or Reconstructionist, I think that attaining a confirmation from the local Jewish Federation saying this is a congregation in good standing in our community, active on an ongoing basis, conducting regular congregational practices, etc., should suffice for the Israeli courts. This is connected to an irony that I think Nikki alluded to, but is worth mentioning. Namely, Reform and Conservative, and towards that end, Reconstructionist as well, is part of an organizational umbrella. Orthodox is not. So the irony is that practically, when one converts under Reform or Conservative or Reconstructionist auspices, one gets a letter of confirmation from a designated officer of the movements that says this congregation is part of the international movement, the national movement, the rabbi is a rabbi in good standing, etc., and that should settle it. With Orthodoxy, there is no umbrella. There is no one international organization. And what happened was that, ironically, converts came from Orthodox congregations, asked for recognition, and the Ministry of the Interior, whether in good conscience or politically and religiously motivated, said, well, we don't know you. Get a letter from the chief rabbinate. And of course, as we know, the chief rabbinate doesn't look kindly at modern Orthodoxy either. And there has been a case that I think is the most telling, namely, when you look at the most famous convert in the world today, Ivanka Trump, she was converted by Rabbi Lookstein, one of the leading modern Orthodox rabbis in America. Well, she didn't make Aliyah yet, but another one of his female converts did make Aliyah. And she sought to be recognized. She was referred to the rabbinic court in Jerusalem. The rabbinic court in Jerusalem said, Lookstein, we don't recognize Lookstein. And she appealed to the rabbinic court of appeal and found herself, and Rabbi Lookstein found himself, in the embarrassing situation whereby the rabbinic court of appeal said, we don't recognize this conversion, and if you want to be recognized, convert again under our auspices, which she did, and came out with tremendous embarrassment, said she feels terrible for herself, she feels terrible for Rabbi Lookstein, but she wanted to get married, and there was no other way that she was able to do so. So Orthodoxy, ironically, finds itself in need of having its conversions validated, or the congregation validated by the Jewish agency. And this is connected, of course, to another irony that is a part of what Nikki alluded to, namely Conversion Bill number 3, number 4, what the chief rabbinate and the ultra-Orthodox parties that are controlling the political religious shots in Israel in recent decades. It's been a long time since the old Mafdal, the National Religious Party, the Mizrahi, was the dominant political religious force. They are as unwilling to recognize modern Orthodox conversions as they are unwilling to recognize Reform and Conservative. So for a change, modern Orthodoxy, Conservative, and Reform find themselves, ourselves, sort of in one basket. Some, like Rabbi Mark Angel, who was here in the last webinar, past president of the Rabbinic Council of America, a tremendous luminary and the great mensch and rabbi, reacted to the pressures of the chief rabbinate by founding, together with his colleague Rabbi Avi Weiss, that many of you know, founding the International Rabbinic Fellowship and basically saying, the hell with you. We, namely modern Orthodoxy, can't subjugate ourselves to the chief rabbinate in Israel. We shouldn't, and neither should the Rabbinic Council of America. So we are starting a new modern Orthodox framework that will stand up for what we consider to be halachically valid and religiously sound. Not everybody shares this opinion. And for instance, in the last newsletter that Hiddush sent out, or the one before, we refer to the fact that ITIM, a leading modern Orthodox advocacy group that does tremendous good, but on this issue, unlike Rabbi Mark Angel, are not willing to come down on this issue and say all conversions should be recognized equally by the State of Israel. So the irony with Orthodoxy is that many in the modern Orthodox community are now more open to collaborate with us, especially with Hiddush, because Hiddush is not part of a denominational setting, is not part of an organizational affiliation with either Reform, Conservative, or any other religious denomination or secular group. And that led to the creation of the vision statement on Israel as a Jewish and democratic state, which is widely supported, and we sent it following the previous webinar, we'll send it again now. We urge you to sign on to the vision statement on Israel as a Jewish and democratic state, because it is Orthodox, conservative, Reform, Reconstructionist, renewal, secular, unaffiliated, who are coming together to say freedom of religion and equality is not a luxury. It's essential for Israel to be true to what it was destined to be, an inclusive Jewish and democratic state. I'll just make a couple more points and then we'll see other questions that were asked. One important thing to remember is the distinction between two sets of categories. One is religious affiliation and national affiliation. In the case of Shalit that Nikki mentioned, the family was secular. They wanted to register their children as Jewish by national affiliation and leave the religion blank. Nationality, national affiliation, was written in the ID card, and the battle was over this issue. The interesting thing is that as soon as the Supreme Court started hearing the case, they came together and advised the government to do away with registration of national affiliation in the ID cards altogether. But of course, Israeli politicians wouldn't hear of it. The irony is, of course, that once Reform conversions were recognized by the Supreme Court, it was now Shas that controlled the Ministry of the Interior that said, what? We are going to have our imprimatur, our signature on ID cards that denote Reform converts as Jews? Nothing of the sort. So they are now the ones who did away with registration of national affiliation in the ID cards. But of course, it's a game because the national affiliation and religious affiliation is still there in the central registration. But if you look at an Israeli ID card for years now, you will see that there is no mention, no registration of national identity. And the one other point that is of interest, and Nikki related to it, what happens to someone whose parents converted out? Now, I actually had a very interesting case that sort of died in the middle because pressure was applied on the poor petitioner to the point that he said, I don't want to pursue it further in the court. But it involved an individual who was born Jewish in Poland and whose parents, who realized that catastrophe is about to happen, gave him to a friendly Christian Catholic family in the village. And subsequently, they were right. Both parents and the older brother were taken to the concentration camps and died. But this baby, who was given about the age of 1 month, grew up not knowing who he was until he was older, much older in life, when his mother, his adoptive mother, told him that for the first time. But by that time, not only did he pursue Christian practice, he became a priest. And once he learned about his true origin, he started looking for his roots and became very involved in Jewish-Christian dialogue, etc., etc. Bottom line, when he retired from his role as a professor in a Catholic university in Poland, he wanted to make Aliyah. And he wanted to be receiving Israeli citizenship as a Jew, even though he was a practicing Christian. Cut the long story short, the bottom line was a new interpretation by the Ministry of the Interior, supported by the Attorney General, which is extremely problematic. As Nikki pointed out, a person who is eligible to rights under the law of return is a Jew, a spouse of a Jew, a child of a Jew, and a grandchild of a Jew. But in 1970, when the law of return was changed, there was another article added that said that the rights of a Jew would be granted even to someone who is not Jewish if he is a spouse, child, or grandchild, provided that he has not converted out willingly, voluntarily. Now, this is a child who was baptized at the age of 1 month. Clearly not a voluntary act. And now the Ministry of the Interior and the Attorney General came up with this disturbing interpretation saying, well, converting out is an ongoing state of affairs. Yes, you were baptized at the age of 1 month, but every day that you do not return to Judaism is a day that you are considered to be someone who is converted out. Now, I was going to fight this out because it stands in contradiction to a previous important ruling of the Supreme Court in the case of Jews for Jesus, a family. And the court held that, yes, the adults who converted out are not eligible to receive Israeli citizenship under the law of return, even if they claim that they feel Jewish and part of the Jewish people. But the child who was converted out by the parents as a minor, she is eligible because she did not voluntarily and willingly convert out. Unfortunately, at that point, the individual did not choose to fight it further. He was intimidated, etc. Long story. But this is definitely an interesting question that has potential horrible ramifications. Because if indeed one is considered as converting out, even if one does not really convert out, by the fact that he has not returned to Judaism, has not embraced Judaism, then what about the Russian Olim, whom the rabbinic courts have been stripping of their Jewish status after converting to Judaism, being born to a non-Jewish mother, just because they are not observant? Is conversion something, a status or a state of legal affairs that is affixed at the time of the conversion, or is it subject to test at every subsequent day since the conversion? And if you do that to a child who was converted out by his parents when it was not done willingly and wants to be considered Jewish, what will you seriously be able to say to the rabbinate that strips Jewish status of Russian Olim? Because they are not sufficiently observant. Yes, Nikki.
Two quick points. One, also, they've interpreted a person who has converted to Judaism, or a person who was born to a Jewish mother, as one. Also, if you converted and your child was born before your conversion, you are not a child of a Jewish mother. So there used to be, the Interior Ministry used to say, if a parent converted and the child wasn't converted with them, that child was still seen as the child of a Jewish mother. It was called a convert brings on another convert. From today, it is not true. So in many congregations, for example, when a parent converts and they have a child, a tiny child, and that child isn't converted with the mother, that child will not be considered Jewish. That's number one. And number two, with your examples, we have numerous cases of the former Soviet Union exactly of that case, and we've had to argue very, very strongly that if the child was converted as a minor and it wasn't done with that child's approval, then that child is not seen to have been converted out. And we actually have won some of those, just so you know.
Thank you. And of course, I see that there is a mention in the chat of something that I started saying, and that is the other distinction, not the one between national affiliation and religious affiliation, but the distinction between who is a Jew for civil purposes, such as the law of return and registration, and who is a Jew for marriage purposes. And this should be understood, and it's not always understood, as I found out. Civil interpretation of who is a Jew, registration of Jewish status in the civil registry, applying the rights according to the law of return is interpreted using civil interpretory measures. The chief rabbinate should have no right and no authority in the matter. I say should have because we've just had a hearing in the Committee on Domestic Affairs of the Knesset last week, when a phenomenon that we wrote about in the last newsletter, and I don't know if all of you are receiving it, but we titled it, "You think you're Jewish? Think again." And what happens is that the Ministry of the Interior and the Population Registry, sometimes based on rabbinic courts' halachic decisions, is suspending civil recognition of Jewish status of an individual and refusing to grant their children registration as Jewish. Marriage is in the domain of the chief rabbinate and is governed by halachic interpretation, usually rigid halachic interpretation that is used by the chief rabbinate. And when Nikki said that we need your help, we need your help in understanding that even though non-Orthodox and modern Orthodox conversions are recognized for civil purposes in Israel, none of these individuals is able to legally marry in Israel. The battle over the right to marry, the right to family, who is a Jew 102, having established who is a Jew 101, is still not fully understood by Jewish leaders and communities and rabbinic colleagues and educators and others. We do need to make sure that we are all on the same page, understanding the challenges, understanding that the overwhelming majority of Israelis are with us, and that's an important element in understanding the picture. Most Israeli Jews want to see all streams recognized equally, all conversions recognized equally, and freedom of marriage being fully recognized. We do need both your understanding and rallying support through your organizational arms, through your NGOs, through your federations, regularly and repeatedly communicating to the Israeli leadership and to the political diplomatic representatives of Israel. This is unacceptable. It's unacceptable to Israeli. It's unacceptable to us. Freedom and the principle of religious freedom and equality is not alien to the Jewish people and not alien to Israel, and should be fully realized and celebrated, not shunned. So with that, let's just see. So Mark Levine was asking, and in a way, you know, he's really giving you a further confirmation. He says, 1 second, if I just find it now. For those who are leaving us, there will be a recording of this session, and if we find out that there are issues you still want to discuss, we may plan another session, and hopefully Nikki, we can twist Nikki's arm and she'll be with us. So Mark Levine writes, a man seeks to make Aliyah. His father is undeniably Jewish. He converted with a local Orthodox rabbi. He has spent 2 years proving his father's Jewish status and his conversion with an Orthodox rabbi, although his father was well known to me and is buried in a Jewish cemetery. He has only lived Jewish life. Why is he having so much trouble? The answer, dear Mark, is very simple. He's having so much trouble because he didn't turn to Nikki or to me. And if he turned to Nikki, you know, the case would have in all likelihood been resolved a long time ago. And that's a lesson that we propose to all those on this call. When you encounter a problem, as Nikki suggested, turn to Nikki, turn to us. There is help and there is a clear willingness on our part to advocate and make sure that you enjoy the entitlement that you are eligible to under Israeli law. All right, there are some more questions that were that came in, but okay, can you please address the issue of Bnei Anusim in Latin America, who due to the Takana from 1927, none of the Jewish communities there will accept a convert or returnee from the Bnei Anusim. What do you say?
The Bnei Anusim problem is a real problem. What's happened is a lot of the Bnei Anusim have formed what they call these developing congregations, because in Southern America they haven't been accepted into the more traditional Jewish congregations and have formed their own congregations, which is exactly the problem that I was referring to before about these developing congregations have been formed by people who weren't recognized as Jewish. They then converted and formed their own congregations. The Jewish Agency is trying to deal with it in a lot of these congregations in Colombia, in Ecuador, in Brazil, and they're waiting for the Supreme Court or the Interior Ministry to come out with new criteria that will deal with recognition of these sort of congregations. I can't solve the issue of in Colombia why the Jewish communities or the traditional Jewish communities aren't accepting the Bnei Anusim or as converts as part of their congregations. But definitely the State of Israel is trying to find some sort of at least way to relate to these congregations. I can't tell you whether there'll be a positive relation or a negative one, but they definitely are aware that there is an issue that they're trying to relate to it.
Thank you. Now, I do want to refer your attention to the background materials that we emailed all those who registered for this webinar that include a fantastic article written by Nikki in 2017 that pretty much in a brief manner describes the whole issue of the law of return and who is recognized, and the translation of those 2014 criteria that the Ministry of the Interior established, which create an interesting situation whereby conversions that are fully valid according to religious tradition would not be recognized by the State of Israel because they lined up all kinds of additional requirements requiring them for the civil recognition under the law of return. And there is an op-ed I wrote and an additional note regarding a couple of proposals that are on the table regarding change of the law, amendment of the law. And this, it brings us to the last point, and we'll end with that. Rabbi Joel Schwartzman is saying, it seems that there have been increasingly strong attacks on the Israeli Supreme Court in an attempt to intimidate and or undermine the authority of this institution. How seriously should we take the threat to the courts? We should take it most seriously. These are not just rumblings. This is a concrete political plan that has found its way to the coalition agreements between the ultra-Orthodox parties and the Likud. Fortunately, blue and white is not part of that agreement. And, you know, as we say in Megillat Esther, who knows if not for that purpose, you have reached kingdom. You have reached the point where you are part of the government. And will they block it? There is an ongoing assault on the Supreme Court, especially from ultra-Orthodox sources and extreme right-wing sources. But when it comes from the ultra-Orthodox sources, it is because they have been able to subvert and subjugate every political partner they had in return for their votes. It's straightforward horse trading, except for the Supreme Court. And what they are trying to do is undercut and undermine the Supreme Court by legislation that would encroach on its authority, and definitely, as Joel Schwartzman is saying, trying to intimidate it. And I'm not sure that they've not been able to succeed, at least to a small degree. And this is a very serious issue. You'll be able to hear a little bit more about it from Rivka Weil in the next webinar, but this is an issue that we certainly have written about before and will continue. Do you want to say something about it, Nikki?
No, all I'm saying is that actually, as far as conversion is concerned, last year, to 2019, the whole issue of the law of return and conversion was taken out of the hands of the Supreme Court, and it's now in the hands of the District Court, for better and for worse. The District Court is under less pressure from the political parties, but then again, there are more appointments made that are by Yelet Shaked in her tenancy, in her ruling of the last, that have really increased the number of Orthodox judges on the District Court. But at least as far as conversion is concerned, at the moment, that isn't a political pressure on the individual judges.
Well, but before you jump to conclusions, this is part of an ongoing trend to alleviate the Supreme Court from certain areas and transferring them to the district courts operating as administrative courts. This does not necessarily have any political underlying reasons, but rather alleviating the court from an impossible burden, impossible caseload. And it has its advantages, as Nikki alluded to. It has some, less advantageous issues. But the assault on the independence of the judiciary is certainly something to be very seriously considered. And the assault of the ultra-Orthodox is not because of the who is a Jew cases necessarily, but because of a whole line of cases that's before the court, such as the Kotel agreement, such as the issue of drafting of yeshiva students, etc., etc. All right, we have had a full day. It feels like a whole day of, the discussion here on the webinar. Thank you all for being with us. There'll be a follow-up email with a link to the recording on YouTube. We urge you to listen to previous webinars that were fascinating and important. Read the materials, the background materials that we sent you. Send us your questions beyond what we've been able to deal with, and we'll try to answer you either in writing or by holding another webinar. Thank you so much, Nikki. Thank you to our co-sponsors, the American Association of Jewish Lawyers and Jurists, J-Plan, the Jewish Pluralism Legal Action Network, Ruach Hiddush, Rabbis and Cantors for Religious Freedom and Equality in Israel, and Shalom from Hiddush. Until the next webinar, July 20th at the same time, Professor Rivka Weil. Shalom and good night. Yes, you wanted to say something.
Who? No. I just want to say hello and goodbye. It was great. I loved it. It was terrific. I can't wait till the next one.
Thank you, Diane. But Nikki, did you want to say anything?
No, I'm just trying to, I just saw now that there are lots of questions on the chat, so I'm not quite sure how I answered the chat if we get off the line, if we get off the...
Well, you will be able to get it, and if you... is there something that grabbed your attention? Well, we are losing most of our participants. What I suggest is that you'll get it in the recording. And if there is anything that you want to respond to or are willing to respond to, by all means, let's do it in writing to all those who registered. Shalom, Diana. I see you on my screen. Thank you, Nikki, and thank you all.
Okay, bye-bye. Be well.
Bye-bye.
Bye-bye. It was great, Nikki. Fantastic. Thank you.
Thanks, Diane.